Item 1 for motion.
Contempt against the deputy commissioner. He doesn't read the court's order or what? Sorry. He doesn't have the habit of reading the court's order or what? Who is this deputy commissioner? Karimganj. Sorry. Who is he? Ask him to file an affidavit why he did not read the court's order. Otherwise, it's a contempt. He's entrusted a responsibility. It's not that you just do it mechanically, whatever you feel like. This Tuesday, tell us what you want to do. Now, what is your information? We gave you 10 days to obtain the information. What is your information now? Sorry. So the deputy commissioner is bound by the report of a DO and not by the court's order. Are you to understand? Is that the submission? Deputy commissioner to file an affidavit before the next returnable day as to why he had again rejected the application for compassionate on ground of late submission when the said ground was rejected by this court in its order dated 10/4/2015 in WBC 1351/2015, and why contempt should not be drawn up against him. We give you 10 days time. You did not respond. Now you are saying that I followed the DO report. I don't follow High Court. I follow DO. So the deputy commissioner is a subordinate to the DO now. We understand. And High Court, let it do whatever it wants. Is that the view? Where is the order dated 10/4/2015? High Court order. Sorry. Yes, Madam Chaudhary, where is the order? 1330. Third MSSP Chaudhary and counsel for the petitioner. The petitioner made an application for compassionate appointment on the death of his father, late Akhlasuddin Ahmed, who died in harness on 17/1/2008. Ahmed, who was made an application of compassionate appointment on the death of his father, who was working as an Assamese language teacher in Zamir Allah ME Madrasa in the Karimganj district, who died in harness on 17/1/2008. The said application was as a said application was not given its consideration, WPC 1351/2015 was instituted, which was given a final consideration by the order dated 10/4/2015, requiring the application or petitioner to be considered on its own merit. It is apparent from the order dated 10/4/2015 that no objection was raised by the respondents that the application itself was filed at a belated stage. Pursuant to the order of 10/4/2015, the matter was placed before the DLC of Karimganj district in its meeting of which meeting? A meeting of 10/7/2017, but the application was rejected by providing that there was a delay in submission of the application. The deputy commissioner, when the issue of delay was not raised in the earlier petition, it cannot further be raised by the respondents, as it would be barred by the principles of constructive res judicata. Accordingly, the rejection by the set aside remanded back to be placed before the next level DLC for its consideration on merit. Deputy Commissioner is put to notice that he should follow the directions of the court, full stop, and not any other authorities, as reported by Mr. P. Saikia, that the Deputy Commissioner was more influenced by the report of the DEO rather than the order of the court. Next item.
Item 4.
Sorry. But you said, we heard you. This is on its own merit and not to reject it on any other. No. Yes, madam, Mr. Yes. Compassionate. DLC, which page? Was not considered. Pass the same order, yes. Give the particulars, name of the father, when he died, where he worked, when you made the application.
Item 3.
Same, not placed. Same order, same requirement. Give the information.
Item 4.
Corruption. Really, your salary is not a corruption. To whom? That is not a corruption. That may be an illegality. Corruption is something different. Maybe. Corruption is something different, and you have to go to those vigilance and all to get your grievance redressed. Make a complaint to the vigilance that somebody is involved in corrupt practice.
And there was a particular document, a fourth document that was found, and we have filed a letter against.
Certiorari setting aside 16/8/2023, annexure 40, page number 172. Just Now, which order you have essayed? This order at page 161, it pertains to the same people, same parties, or somebody else. You have annexed a court order. It's between the same parties. Now, where is the impugned order? Page 172. Uh, When your officers pass order, why do you write petitioner, respondent and all? They are not petitioner before him. He is passing an order as directed by the court. So once you use the terminology petitioner, respondent, we don't know whom you mean. Why can't he use the name of the person? Well, now it is very difficult for us to read. And moreover, when there are multiple litigations, we don't know X was a petitioner in which case, Y was a respondent in which case, and which order this officer means to describe the petitioner and respondent. Just a minute. This is provincialization under which act? 17 Act or 2011 Act? No. The line of this secretary at page 175. The claim of the petitioner for provincialization cannot be considered as he had been appointed in excess. So this is, you are considering as per 17 Act or 2011 Act? Because the reason is he is excess. So if we have to examine, first we must know under which act he was considered. Petitioner, now again, petitioner of the secretary and our petitioner, same person or different person? Same person. Petitioner means Madam Talukdar's client. Okay. So now, he's in excess. Why does he say so? So both are Hindi teacher, I understand.
it should turn to a once instead of this.
I read it. I've read the whole order.
It is a particular jurisdiction, the petition was mentioned as state petition, not as jurisdiction.
So one mentioning, will it change it? If you appoint and make a person to work as a Hindi teacher, just because you use a nomenclature assistant, will you cease to become a Hindi teacher? Mhm. (151). There's something wrong, Mr. Chisti. It doesn't appear to be a very clean order passed. Don't provincialize the other man also. No, who? Other one is also not provincialized. This person is also rejected. So if other one, just a minute. You have a post of Hindi teacher to be provincialized. I understand. If the other man is out, there is only one claimant.
There's no post of jurisdiction in that particular.
No post of Hindi teacher.
There are three, there is
One?
There was no better for the Hindi teacher in posting board of company type to.
173. Where? 173. 175. There was no post, no vacant post of Hindi teacher. Post was there. There was no vacant post. Just a minute. If the post was being occupied by a man obtaining some fake orders, that means it is a vacant post. Or else you are giving due consideration to a fraudster. If a fraudster occupies a post, later on detected, can it be construed that the post was occupied? By whom? By a fraud. You can't take that view. Mr. Chisti, I've not gone through the entire gamut. I'm just taking note of your submission that the other man, some fake something was found. Fake means fraud. If that man was occupying this post, you cannot say that this is not a vacant post.
At the time, some other persons were trying to one. So we also doing.
So Bina Chaudhary is gone long time back. So suppose on the date of his appointment, Bina was there. Okay. But you still appoint him. He continues. In the meantime, Bina goes. He steps into the shoes of Bina in that post. How can you ignore that part? Have you traveled in city bus? Have you traveled ever in city bus? Or, not nowadays. Okay, good. Suppose all the seats are occupied. One man is standing. Before he reaches the destination, if one passenger gets down, don't you occupy your seat? Why same principle is not applicable? Suppose on the date of admission, the appointment, one Bina was there. Bina a little later left. This man continues. Will he be forever be an excess? Definitely no. Please, we have given you 5 or 6 opportunities to examine, but you are not examining in the proper perspective. Approach and attitude is to not to look into the grievance, but how to reject it. And Mr. Chisti, finding reasons to reject is one of the easiest. If you tell us, we will find it the easiest way out. We'll dismiss every petition. You tell me, I'll find one reason or the other to dismiss every petition that is listed. And it will be a correct order. You cannot challenge it in appeal also. But is it the proper approach? Or the proper approach is to look into the actual grievance and then try to find out how to give it. It appears Secretary has adopted the other procedure. Let me find out a loophole here and there, and nothing is perfect. No matter is perfect, 100% perfect. There has to be one loophole or the other. But if you latch on to that loophole and reject everyone, who will you give then? You have to give it to also to somebody. Both ways, we can't accept this vacant post. If Bina was there, this man subsequently steps into the post. If it is occupied by a fraud, under the law, we cannot understand that it's a vacant, it's a post occupied. And after all, these people had rendered service for how many years now? 20, 30 years. And all along we have extracted their service, not that. And what will you do with this post? Suppose you don't provincialize this man. That post is definitely there. What will you do with it? You recruit somebody else from outside. Why? The experienced man of 20, 30 years is not required, and the new man will come in. List on Wednesday for further consideration. The respondents in the Secondary Education Department to inform the court as to why in paragraph 3 at page 175 of the order of the Secretary dated 16/8/2023, it had been understood that when the petitioner was appointed, there was no vacant post of Hindi teacher in the Paschim Bonbhag Anchalik High School. List on Wednesday for the information. Amalgamation. So now what is your grievance? Impure order dated 1910, which merged Uttar Toltola with Mirza Nagar.
Yes.
So you are agreed by this order.
Yes.
Why? Today, your school is merged with that one.
Yes.
Yesterday, that school was merged with you.
And earlier order was passed by the commission.
And the earlier merger is still subsisting, or it is?
Subsisting. They did not join.
They means they had refused to join.
Right. And commissioner has passed the earlier order, and second order is passed by the director.
Yes, Mr. Chisti. That school must be not very happy to join with this school. And they somehow they flout your orders. Now go and convince the director that do it the reverse way now. Merge that one with us. Where is your 18 order? First leader. 2018 order. 16. Where is that list? Uttar Toltola.
Yes.
Just a minute. Your school is Uttar Toltola. Details of merged. Uttar Toltola is merged with whom?
My lord. The fourth
Name of the school
murder.
to be merged, I think, cannot be merger. Name of the school to be merged and name of the school, no, both are name of the school to be merged, name of the school to be merged. Both are to be merged. How do you know that your school was merged with that one? Or that school was merged with you? How do you know?
My lord, that speaks about that, my lord, earlier order is accepted, certain. And then because of the enrollment and interest of that particular school is better than that, because of only better.
Means other school is better. So the requirement is whoever is having more enrollment, he will remain there and the less enrollment will.
That is not. I'm waiting for the. It's for the betterment of the student and all those.
Oh, I think we have been following it.
And
See, Mr. JMH Chaudhary, under what logic a school having more number of students will be merged and sent to another one? I think it's quite acceptable what he is saying.
There, my lord. Assam, right to child, free and compulsory education is good.
Everybody is aware of that. That doesn't provide for any answer to this one.
1 kilometer, my lord. There should be one at least. There is a case, there is no school between 2 kilometers from our school. That I say.
Sorry, to have a merger, there must be two schools within 1 kilometer.
Or, my lord, every school, that is. Every village, there should be a school, 1 kilometer, 1 kilometer. There should be a LP.
Huh.
There is a case where there is no LP school within 2 kilometers from our school.
No village, no school within 2 areas. Very well. So why you cannot be merged?
Oh, my lord,
No,
what does it face problem, my lord?
No,
There is a lake of.
Mr. Chaudhary, we are not here to decide problems. If you have problem, go and file application before the secretary.
But who are not in our.
See, under 226, we can only entertain if there is a illegality. Some law has been violated. But convenience, inconvenience, you have to go to the secretary. He will find out who is having more convenience. And plus, under the law of merger, you have no right to remain where you are. That
Law, merger state.
why are you going for a dismissal? If I record your submission, it will go against you. Ultimately, your petition will be required to be dismissed. Better go there. Only acceptable reason we find, Mr. Chaudhary, that inconvenience. Inconvenience, you will consider it because it's a factual determination, whether inconvenient or not, or whatever it is. We don't observe anything. An order dated. Whose order is this? No, first order is gone. An order dated 9/10/2023 of the Director of Elementary Education, Assam, whereby the petitioner school, namely Uttar Taltola LP School, had been merged with Mirza Nagar Lower Primary School. 452 number Mirza Nagar Lower LP School. Taltola, you have no number. You are a numberless school, therefore they have merged you. Adharan is a stronger school, they have a number. Here is school. It's a GM Chaudhary and counsel for the petitioner, apart from the other grounds, has also raised an issue that if the murder is given its effect, it would cause inconvenience to the students of Taltola Lower Primary School. The aspect of inconvenience being caused would require a factual determination, and therefore we are viewed that it would be more appropriate for the petitioner to file an application before the secretary to the government of Assam in the school education department, which again would be in conformity with clause so and so of the notification provided for the, which clause? 14, not 14. 19. Yes, and 19 of the notification providing for merger. The application be filed within 7 days. A status quo be maintained for 7 days, but in the event it is not filed within 7 days, the order, interim order will no longer hold good.
Item 6.
And thereafter, you ask the secretary to pass interim order.
Working as a national sector around in between several
should not be regularized as lecturer. I think we have to issue notice here. Mr. M.A. Islam, Council Petitioner, Mr. K. Gogoi for the Higher Education Department. Notice 6 weeks, extra copies 3 days. Any private respondent? Steps upon respondent 3-4 registered post 3 days.
7.
Mr. Kolita. I think this was the case for notice. NK Kolita. S2TO for secondary or elementary, madam? Elementary Education Department. I think all the respondents. Extra copies 3 days.
Item 8.
Mr. Khan. Compassion and where is DLC? 1330. Rejected. On what ground? Page number 32. What is the name of this petitioner? Deepak Kumar Saha. Where is the name of Deepak Kumar Saha? 32, where is his name? Serial number 16. Application due to overage. Due to want of vacancy. Just a minute. And who are recommended? Amongst the this 22 recommended. 22. Why do you don't have the habit of giving a reason? It's of which date, this one? After 6 years you have come, what can I do? See, had you come in time, maybe I would have stayed this recommendation. But you come after 6 years, they are already appointed. Why should you disturb their appointment? It is, Mr. Khan, it is for the litigants to be more vigilant. You can't keep sitting at home. Mr. Khan, the ground level reports that we have, people are fanning around the state asking, do you have any case of compassionate appointment? And whenever somebody responds to this system, yes, I have one, they come and ultimately it reaches this court here. Hmm. This man must have totally forgotten about it. So some person of the system reminded him, got the brief. Yes, we'll go to the High Court and get it done. This is what is going on. Otherwise, there is no reason why people will come after 6 years, 7 years, 10 years. Hmm. Should we entertain this kind of petitions? See the difficulty you are creating. You had a very good legal right. We would have easily stayed 22 to 28. That no reason is there. Give us the record whether you had compared their financial condition or not. And if not, we'd have set aside the whole thing and sent back. You would have got the benefit. But passage of 6 years, these people must have been appointed. You should have challenged, as you are benevolent to the selected candidate, even if your right is violated. Why are you here after 6 years now? Now we are not going to entertain their challenge after 6 years. Even if they're illegally recommended, let it remain. Yes, Mr. Sekia, what to do? This is from which district? Tinsukia. Go ask the department to that clause, what it was, 15, to whether other vacancies are available. That's the only way out, no other way. Which is that clause? You have to examine whether vacancies in other departments are available. Which clause? Paragraph 15. Please check up the paragraph number. 15. Heard Mr. Ram Khan right here. The father of the petitioner, Narendra Kumar Shah, who was a Hindi teacher of Adarho Hindi LP school in the Tinsukia district, died in harness on 27 to 2016. And on his death, the petitioner made an application for compassionate appointment on 13/5/2016. The said application was considered by the DLC of Tinsukia district in its meeting of 26/7/2017. But the application stood rejected by providing that there was no vacancy available. It is noticed that some recommendations were made, meaning thereby it cannot be a case of unavailability or vacancy, but it was a case of rejecting the petitioner without any appropriate inter-se comparison with the other recommended candidates. No reason is given as to in the resolution as to why the other candidates were recommended, which itself makes the order unsustainable in law. But as the petitioner has approached the court after 6 years of the rejection, we are not inclined to go into that aspect. But however, it is noticed that as per clause 15 of the OM dated 1/6/2015, there is also a requirement to examine as to whether vacancies are available in other departments to accommodate the compassionate appointment, which apparently had not been done in the instant matter. Accordingly, the education department to which the deceased employee belonged to confer with the other departments in the district as to whether vacancies are available, and if the report received would be that vacancies would be available, the matter be again placed before the DLC of Tinsukia district for its consideration.
Item 9.
Page number 60, 37. Just a minute, where are you reading? 37, 9, 10, 11. Pandey. rejected due to qualification not covered for the post. Again, same thing. Wherever is এটা লিখিব father, name of the father? Ramakanto. Ramakanto Pandey, headmaster, Panitola Hindi ME School, Tinsukia district, died 15/3/2015. Application made on 9/6/2015. DLC dated 26/7/2015. By the said resolution, the application or petitioner stood rejected by providing that he was not qualified for a post of assistant teacher. It does not require a reiteration that an application for compassionate appointment is made against any available vacant post for which the applicant may be qualified, and it is not an application for a specifically identified post. If the petitioner is not qualified for the post of assistant teacher, it is also incumbent upon the respondent DLC to consider him against any other vacant post for which he may be duly qualified for. In view of such infirmity, the rejection by the is set aside, remanded back to the DLC to be placed in its next level meeting for de novo consideration as per law.
Item 12 for admission.
Yes, item 12. Including as respondent. Why you're a necessary party? Members of the committee. So why are you a necessary party? What is the grievance raised? Just a minute. Depend on the relief they are seeking. Set aside and post the letter dated 8/9/2022. Eight 9/2022, which page in the writ petition? The impugn order 8/9/2022 is in which page of the writ petition? No, they have challenged one order dated 8/9. In which page it is available? 37. Rukun, are we appearing for Rukun Ahmed? You are appearing for whom are you appearing? Members. How you are a no, how you are a necessary party in this proceeding? Just a minute. 14/11/2022. What observation was given? Which observation?
SMDC of the school shall not be able to take any financial decision and transaction with regard to the funds allotted to the.
Okay, so the members are affected. Understand? Yes, sir. Yes, Mr. Impleadment petition, you have not served on it. Because they have a right to object. We may allow, we may not allow is a different aspect, but at least they have a right to object. So. It is stated that the copy of the interlocutory application seeking impleadment as respondents had not been served on the writ petitioner and the other respondents. So list again after service of the application next week.
Correct. 1st December. Item 13.
None appears adjourned.
Item 14.
Yes, 14. Today, what is to be done? By whom? Who are they? Secondary education. Secondary education, who appears? I think it is, no, some higher secondary council. Not department. Department will be secondary. Who appears here? No. Secondary education department is a respondent. Higher secondary council is also a department. Or is a respondent, I will. So, do you want to file affidavit or not required? Required. The cause list defect also. Secondary. Mr. SMT Chistil and counsel appearing for the secondary education department expressed inconvenience in as much as the list shows. In as much as the cause list shows it to be second standing council of the higher secondary education department. We have been informed that there is no department called higher secondary education department. Whereas on the other hand, there is a higher education department as well as a separate secondary education department. What to do now? However, Mr. Chisti prays for 4 weeks' time to file the affidavit. Pray aloud. None appears for the respondents in the Assam Higher Secondary Education Council. If they don't appear next time, we'll go ex parte against them. What to do?
Item 15.
Senior, no. Today, what we do, Mr. Bishwakarma, S. Bishwakarma. Mr. S. Bishwakarma enters appearance for respondent number 5 and prays for how much? Prays for 3 weeks time to file affidavit. Pray aloud. List after 3 weeks. Also, you have filed your affidavit. 6 for an adjournment. Pray aloud.
Sorry, December. Item 16.
16. Counter affidavit has not been filed. More by respondent number BTC. You want to file? Have you filed?
No.
Mr. B. Chaudhary for the BTC prays for 2 weeks time to file affidavit. Pray aloud. Just after 2 weeks. Sorry. Date is that side.
18 December. Item 17.
Except file countered having regard to issue of remaining official, who appears for 6 and 7? You are appearing. And who appears for the state respondents? Secondary education and deputy commissioner. The intent to file affidavit. No, there is an order. Although 6 and 7 have filed affidavit having regard to the issue involved, counter affidavit or remaining official respondents will be necessary. No, I don't know. Look at the judicial order. So if you don't want to file, I'll record that Mr. Chisti says there is no requirement. And if you want to file, how much time you want? 2 weeks. Both Mr. SMT Chisti and also Secondary Education Department, Mr. P. Sakia for Deputy Commissioner. Which district? Lakhimpur prays for 2 weeks time to file affidavit, pray now, list after 2 weeks.
Item 18.
Who appears? Mr. Gogoi appeared as CGC and medical education, health possibly. Mr. Gogoi, you appeared as CGC. And Mr. B. Gogoi appeared for the medical education department. Your name, Borua. Mr. H. Borua, Land Council appearing medical prays for 2 weeks time to file affidavit, pray aloud. List after 2 weeks, interim order to continue. Mr. Gogoi, K. Gogoi, you want to file affidavit? Not required. Okay.
Item 21. Medical education.
Yes.
Health. 18 December. Interim. 18.
No, understand. Today, what can I do? Mr. A. Fukan for Elementary Education Department, Girin Pegu for Deputy Commissioner. Mr. SMT Chisti, Council of Elementary Education Department, prays for 2 weeks time to file the affidavit. Mr. P. Sakia for the Deputy Commissioner, Jorhat also makes a similar prayer. Both prayers allowed. List after 2 weeks.
Item 22.
Contempt matter. First time it's coming. Where is the order violated? 40. You served the copy. Has the copy of the order been served? Your Begum, N Begum. Notice 6 weeks, 6 of steps raised supposed to. Sorry. Is it ever? Can you, in contempt, can you do it? I know some courts are allowing it, but in a contempt, can it be done? Writ, yes. Civil court cases also, yes, but contempt, check up the rules. Because contempt is a little different jurisdiction. But if you can convince any of them to accept the notice. Sorry. No, this is a contempt coming for the first time. No, to accept the notice. Will you accept it?